Welcome to another episode of the Divorce Lawyers podcast, where we dive deep into the legal intricacies of family and divorce law in Ontario, Canada. I'm Deepa Taylor, and today we're discussing a critical topic that affects many individuals and families: recent changes to the Divorce Act, variation and suspension. The Divorce Act underwent substantial changes in March 2021, bringing in new provisions and clarifications that are essential for anyone going through a divorce, particularly when it comes to varying, rescinding, or suspending court orders related to support and parenting. Today, we'll explore these changes in detail, focusing on what they mean for you and your family. Let's start with a bit of background. The Divorce Act is a federal statute that applies across Canada, which means the provisions we're discussing are relevant nationwide. However, today's discussion will focus particularly on how these changes impact families in Ontario. Section 17 of the Divorce Act is where we find the provisions on variation, rescission, and suspension of orders. This section allows parties to apply to change the terms of an existing support or parenting order. But it's important to note that a variation under the Divorce Act is not an appeal or a new hearing. Judges are generally limited to making adjustments that are necessary to reflect new circumstances without starting from scratch. The first thing to understand is that Section 17 has been updated to reflect modern understandings and needs, particularly regarding family dynamics and children's welfare. The changes made in 2021 focus on making the language and provisions more child-centered and less adversarial, which is a significant shift from the previous approach. One of the most critical updates is the change in language. The term custody has been replaced with parenting orders, and access has been replaced with contact orders. This shift in terminology is not just cosmetic. It reflects a broader effort to minimize conflict and focus on the best interests of the child. Under the revised Section 17, parties can apply to vary, rescind, or suspend an existing support, parenting, or contact order. The court may make an order varying these terms either retroactively or prospectively, depending on the circumstances. A key point here is that the court will consider any material change in circumstances since the original order was made. This material change is crucial because it's the basis upon which the court decides whether a variation is warranted. The new language emphasizes that any change must be significant and directly impact the child's welfare or the financial situation of the parties involved. The concept of a material change in circumstances is central to any application for variation. But what does it mean? Essentially, it refers to a change that is substantial and unforeseen at the time the original order was made. For instance, a significant increase or decrease in income, retirement, or even changes in the needs or conditions of the child could qualify as material changes. Interestingly, the new provisions do not explicitly use the term material in all instances, which has raised some eyebrows. Some legal professionals wonder why the legislature didn't clarify this term more explicitly, especially given its importance in family law. However, the courts are expected to continue interpreting material change in line with established case law, ensuring that only significant changes justify a variation. Another notable addition is the provision that automatically considers a former spouse's terminal illness or critical condition as a material change in circumstances. This is particularly important because it ensures that the court addresses any impact on the child's welfare swiftly and with the seriousness it deserves. This provision removes any ambiguity, ensuring that these serious health conditions are recognized immediately as grounds for revisiting parenting and contact orders. It's a compassionate inclusion that acknowledges the profound impact a parent's terminal illness can have on a child. Relocation is another area where the Divorce Act has introduced significant changes. The new provisions deem the relocation of a child as a material change in circumstances. This means that if one parent wishes to move with the child, this move is automatically considered a significant change that can justify a variation of parenting or contact orders. However, the Act also clarifies that if a court prohibits relocation, that decision alone does not constitute a material change. This is to prevent a situation where a denied relocation could be used as grounds for further litigation, which could be seen as an attempt to relitigate issues that have already been settled. The Act also introduces a new provision prioritizing child support over spousal support in variation applications. This is a critical change as it codifies the principle that the financial needs of children must come first. Child support is calculated first, and only after that is spousal support determined based on the remaining financial resources. This change reinforces the idea that the welfare of children is paramount, and it ensures that their needs are met before any other financial considerations are addressed. One of the more revolutionary changes in the Divorce Act is the removal of the maximum contact principle. This principle previously suggested that a child should have as much contact with both parents as possible, provided it was in the child's best interests. However, this has been replaced with a more nuanced approach that focuses solely on the best interests of the child, without any presumption of equal or shared parenting. This change reflects a growing recognition that equal contact is not always in the best interests of the child, particularly in situations involving family violence or where one parent is not capable of providing a safe environment. By removing the presumption of maximum contact, the new provisions allow the court to focus more precisely on what arrangement serves the child's best interests. To wrap up, the recent changes to the Divorce Act represent a significant shift toward a more child-centered approach to family law in Canada. By focusing on the best interests of the child and removing outdated or adversarial language, these updates aim to reduce conflict and promote more collaborative solutions in family law matters. If you're facing a situation where you need to consider varying an existing order, or if you simply want to understand your rights and obligations better, it's crucial to consult with a family law professional who can guide you through these changes. For personalized guidance, please consult one of our family lawyers by visiting DivorceLawyers.ca. Thank you for joining me on this episode of the Divorce Lawyers podcast. If you found this discussion helpful, please subscribe and leave a review. We'll be back soon with more insights into the ever-evolving world of family and divorce law in Ontario. Until next time, take care.